Third-degree criminal sexual conduct in Minnesota is a frequently charged sex crime, and there are many subparts to it that prosecutors have options about on how to accuse or how to charge. And today I'm going to talk about one of the more common and more severe forms of third-degree criminal sexual conduct, and that is what's called force or coercion. And that statute, if you're looking at the criminal complaint, which is the charges against you or maybe one of your loved ones or family members, is the statute number is 609.344, subdivision 1, parenthesis C. That's the one I'm talking about. And what the law says about that is this. This is for Minnesota. A person who engages in sexual penetration with another person is guilty of criminal sexual conduct in the third degree if any of the following circumstances exist. And the one I'm talking about today is C. The actor uses force or coercion to accomplish the penetration. So first let's talk about penetration. The definition of Minnesota about penetration for criminal sexual conduct means penetrating any of the private areas or intimate parts, however slight. So that, for example, that can mean a finger. Let's talk about a finger into a woman's private area or vaginal area. If even one tiny, tiny little part of the finger parts those lips in that area, that's penetration, however slight. So in other words, a lot of people might think, well, doesn't penetration mean that you've really put something up most of the way up in some area? No, it does not. Penetration, however slight, into the intimate parts is considered penetration in Minnesota. So we'll see that certainly with a penis and a vagina. It can be with a finger and a vagina. It can also be oral sex, male to female or female to male, or male to male or female to female. Or finally the anus area as well, a finger, a penis, or a tongue. Any of those things can be used or alleged to have committed penetration. The other part, though, that I want to really talk about today is this force part of it. Under the definition, again, this is in parentheses C, Minnesota law defines what force means. And the reason this is so important is this. There are many types of ways to charge out a third-degree criminal sexual conduct. Some of them do not presume a prison sentence. In other words, under Minnesota's sentencing laws, if you have no criminal history and you're found guilty of this or plead guilty to this, you may be able to not have a judge presume that you're supposed to go to prison, and maybe they can give you local jail time or community service or treatment or whatever. But some types of third-degree criminal sexual conduct, including force or coercion, requires a judge to presume a 48-month prison sentence, even if you've never even had so much as a speeding ticket in your life before. That means that you're going to prison. You're not going to jail. You're not getting work release. You're not getting home monitoring. You are going to prison, or that's what the law presumes. And if you plead guilty or are found guilty of that, the only way to avoid that would be to have the judge give you a departure, which you have to make a strong showing to get, and not everybody gets them, of course. So this is more serious than some other types of third-degree criminal sexual conduct in Minnesota. And today I'm just going to focus on what force means. What does force mean? Well, certainly we can all imagine what force means in our head to create or to cause penetration in a sex assault allegation. That certainly would mean an example like pinning somebody down or threatening them with a knife or something like that. We can all imagine that would be force. But the definition goes further than that. I'm going to break that definition into two parts. It's also found in the Minnesota statutes. Here's what it says. I'll read the first part first. Force means the infliction, attempted infliction, or threatened infliction by the actor, that's the defendant, of bodily harm. Okay, so let's just start with that. So certainly pinning somebody down and causing them to feel pain in their arm, that could be the infliction of bodily harm. It doesn't have to necessarily result in cuts or scratches or anything like that. Attempted infliction, that might say that you're trying to scare them into it, or attempting to hurt them even if it doesn't technically hurt them. or threatened infliction. Now that's a threat such as I'm going to cut your throat if you don't do this, or some sort of violent threat like that. Those are all just examples. That's not the entire list of things that could be charged out that way, but those are some examples about what force can mean. Here's another part of the definition, the other half of it, if you will. Or the commission or threat of any other crime by the actor against the complainant, that's the alleged victim, which causes the complainant to reasonably believe that the actor has the present ability to execute the threat, and as long as the actor doesn't have a significant relationship like parent, child, uncle, nephew or niece, teacher, student, things like that, also causes the complainant to submit. So if there's a threat made by the defendant, an alleged threat, or crime, another sort of crime, like a robbery or a burglary or something like that, and they make this threat and they say that causes the accuser to reasonably believe that the actor has the present ability to do it. So for example, let's say they say a 10-year-old kid breaks in the house and says, if you don't give me all of your money, I'm going to rape you. Well, I don't think most people would think that a person would have a reasonable belief that the actor has the present ability to do it. But you can imagine a lot of scenarios where indeed it would be alleged that the complainant did reasonably believe that the defendant could carry out this threat. And again, as long as there's not a significant relationship like parent, kid, uncle, niece, etc., also causes the complainant to submit. So they've got to not only have that threat, but then make the person submit because of that alleged threat. So these are examples of force. Again, it's not the whole list. There are a lot of scenarios, and the law is kind of ever changing. But one of the more frequently types of criminal sexual conduct that I'm seeing charged out in recent times, and that's the last 5 years or so, is third-degree criminal sexual conduct by force. So I wanted to give people an idea of what this definition means. There are, of course, several defenses to this, and they range quite a bit from we had consensual intercourse, and even if there's any, sometimes there's injury associated with sexual intercourse. Some of it's very normal, and I've seen doctors testify about that while there can be some stretching or very minuscule tearing in the vaginal area, that doesn't necessarily mean that the sex was forceful. That can happen with completely consensual sex as well, but we'll do see a charge sometimes. Some person on the prosecution side testifying for the prosecution will say if there's injury there, then that's consistent with force. The medical community and medical literature will tell you that there's no way to say that that's consistent with force as opposed to regular consensual sex, depending on the facts. But it is something we see, for example. And again, these are serious crimes because if you're convicted or plead guilty to this third-degree criminal sexual conduct force allegation, you're looking at about a 48-month prison sentence without ever having been in trouble before. Of course, if you have been in trouble before, it's much longer. Now, we're living in times, too, where we'll see situations where people will say, listen, either A, we never even had sex, that's not true, or B, yeah, we had sex, or there was some, insertion of the finger, we were fooling around, not quite sex, but, other sexual acts without actual intercourse, but it was all consensual. And the accuser will say, no, I was forced into this, they threatened me, I felt like I wasn't able to leave their bedroom, they're bigger, they're stronger, whatever like that. There's a lot of different types of allegations and scenarios, some true, some not. And of course, it's a very scary situation for anybody to be accused of this, and can absolutely be life-altering, not only for the accused person, but for family members that are near and dear to the accused person and that may know them and say, this isn't them. Either they would never do something like this, or or this was an aberration, that maybe they got intoxicated and they didn't do what they would normally do or whatever. Nonetheless, they're very serious situations, and obviously you're going to want to talk to a lawyer that understands the nature of these laws and how to defend these cases and how to make proper recommendations. Sometimes the defense is, this didn't happen, and a person wants to go to trial. Other times it's something like, we got drunk, I should have listened, I was told no, I kept going. Or, yeah, I did something, but I didn't do quite what I'm accused of. It's not as serious as what they say. Every situation is different. You need to have a lawyer that's going to listen to your situation and make sure that they're going to honor your side of the facts and what potential defenses may exist, and be able to guide you. Is this a situation where you should seek a plea that's fair based on what you did or didn't do, and make sure you get any help if you didn't make some good decisions there? Or is this a situation where you're falsely accused and maybe it feels like nobody believes you and everybody's attacking you right now, or assuming that because you're accused of this, it happened? We've seen that happen to a lot of people, and it's not fair. You are to be presumed innocent, and you ought to be able to have your story heard as well before anybody passes judgment on what somebody says happened or not, especially when it's there's two people in the room and one person saying this happened and the other person saying absolutely not, it didn't happen this way. You really need to make sure you have a good defense lawyer that's going to understand how to tell your side of the case as well, and hopefully protect your future. If you have any other questions, I'm criminal defense attorney Ryan Pacyga. You can call me at 612-339-5844 or find me at www.arrestedmn.com.